the badgers in, and we'll get this underway, shall we?
Okay then.
Let's go. Okay, good evening and welcome to our Wednesday evening seminar. Tonight, our topic is Exterminate. We'll be looking at contractual and common law termination. And taking us through this is Mr. Jon Sharp, who is a consultant solicitor at Fletcher Day. As always, John is delighted to answer any questions that you may have. Please feel free to use the chat or Q&A boxes in the bottom toolbar there. If there's something you'd like to ask him on the topic, but you don't necessarily wish to do so in an open forum, please feel free to email him directly. That's jon.sharp, jon.sharp @fletcherday.co.uk, and he will be delighted to assist. Okay, without any further ado, John, I'm handing over to you.
Well, thank you very much, Julie. Good evening, everyone. Exterminate, contractual and common law termination. It's an interesting topic, and it wouldn't be, for those of you who have seen me present before, if I didn't get the words in read your policy wording. The same actually applies to contracts. The reason I've always encouraged people when I'm giving talks on insurance to read their policy wording is that that is the contract that you have between yourselves and your underwriters. There is no difference. Contracts need to be read, and read carefully for the reasons that I'll explain. Just one further point, it is absolutely hammering it down with rain in Scotland here, so it's likely to get heavier. I'm in my conservatory, so if the noise gets too much, please just email Julie and I will just basically shout louder. There I am. There's enough about me. I'm on the website, etc. The point I was making earlier is actually a very simple one. You need to read your your contractual documentation. The courts, rightly, assume that if you've entered into a contract with somebody, that you have both agreed that contract. So you've both read it, you understand its terms, and you've agreed to enter into that contract. It's always very important, therefore, that if you don't understand the term of the contract you're entering into, or that you're not sure whether you should be doing this in the first place, that you should get some legal advice in relation to that. It has always been a frustration for me, after nearly 35 years in practice, that sometimes people come to you and it's too late to do anything about it. The contract's been signed. The courts are reluctant to interfere with parties' agreed contractual obligations in the absence of, primarily, firstly, one party being forced into entering into the contract, i.e. gun to their head situation, or that they have felt in some way obligated or some other. In the absence of that sort of scenario, the courts are reluctant to enter into or interfere with parties' contractual obligations. They assume you knew what you were doing. However, there are certain circumstances in which the court will interfere. Sorry, the rain is getting heavier here. I'm going to shout louder. Termination rights. The right of the innocent party, i.e. the person that's not in breach of the contract, to terminate a contract because of breach by the other party will arise in the following situations. Firstly, where there is a breach of a term of the contract which is so serious in itself that it would be unreasonable to expect the other party to continue with the contract. This is a fundamental term or a condition as opposed to a warranty. Now, let me explain the difference between a condition and a warranty. A condition is a fundamental term of the contract. So, for example, in a supply contract, it may be that one party has agreed to pay to the other X amount per month on the basis that they then receive the supply of their goods. Yeah, I think we're all there with that one. Now, if that party who's expecting to receive the supply of goods doesn't pay in accordance with the terms of the contract, then that means that the supplier is not going to supply the goods. That's fundamental. It's a condition of the contract. Compare that to a warranty where, adopting the same situation, the buyer of the goods under this supply contract has warranted that he'll always have, I don't know, £10,000 in the bank. Yeah? That's a warranty. He's saying we'll always be able to pay because we will always have 10,000. Now, it may be that he then borrows the money from somebody, but still fulfills his condition, which is to pay X amount a month. So there is a difference between a condition and a warranty. Conditions normally lead to termination of a contract. Warranties don't necessarily lead to the termination of a contract. The position is slightly different in insurance law, but for contract law, that's the general principle. If anyone can't hear me, as I said, please email Julie and I will talk louder.
Currently, John, we can hear you absolutely fine. It's probably more of an annoyance for you.
Okay, that's great. Thank you, Julie. Repudiatory breach. Repudiatory breach, breach of a fundamental term. Failure of the owner to give sufficient title to enable the work to be carried out lawfully. In a construction contract, that obviously causes problems. You're expecting, when you turn up to start work on a site, that you're lawfully, you can do that. But if the owner of the land hasn't got necessary consents, permits, etc., you can't start work. That's fairly fundamental to the whole contract. So failure of the owner to give sufficient time to enable the work to be carried out lawfully, or a sufficiently severe and not merely temporary failure on his part to provide information or possession, but in all cases, the whole contract will need to be examined, including any express rights to compensation or extensions of time which may be afforded to the contractor in circumstances that I've just described. So you turn up on the contractual date to commence work. The employer has not obtained sufficient planning permission, for example, would be a classic example, for you to start the work. But it's due any day, and he's got an email that says, look, I should get this tomorrow. You go, okay, fair enough, we'll come back tomorrow. But if he says to you, oh, it's going to be at least 6 months and I'm not sure it's going to get granted, oops, that's when you may well have the opportunity as a contractor to say, well, hang on a minute. This isn't what's said in the contract. The contract will normally stipulate that all planning permissions, etc., are in place. You should be able to say, sorry, that's fundamental. We have set aside labour, materials, works, etc., to commence work on this date, and now you're telling us on the day we turn up that you haven't got the planning permission. If then the owner was to say to you, well, I still want you to carry on and do the works on time, that's, you can say, yeah, we're not doing that. We can't do it because you have failed in your fundamental obligation to obtain planning permission so that we can carry out the works. The engagement of additional contractors to execute the same works already contracted to another contractor is also a repudiatory breach. Failure to pay one installment out of many due under the terms of the contract is not ordinarily sufficient to amount to repudiation. The example I gave earlier was of a supply contract. If you miss one installment, that's probably okay, as long as then it's caught up at the end, because you would have a right to go to court and say, I was due to be paid this, and I haven't been paid it. But a failure to pay 3 installments, where the employer did not evidence any intention to pay, was held not to be a repudiatory conduct. A failure to pay is less likely as well to be repudiation if it occurs towards the end of the contract. That's perfectly correct. If an employer has been paying you regular sums whenever you have submitted an account, there is normally, at the end of the contract, well, look, I've already paid you for that under payment 3. I'm not paying you to you again under payment 6. So there's always a little bit of a negotiation at the end. But would that be a repudiatory breach of contract? Probably not. Abandonment of the site by a contractor or removal of plant or site offices will prima facie be a clear fundamental breach in the absence of some very special explanation. Now, during COVID-19, contractors were put in, well, a continuing situation, but certainly in the early days, it was often the case that the contractors would turn around to the employer and say, look, just at the moment, we haven't got the labour, we haven't got the plant, we haven't got the materials in order for us to carry out the works on this site. We're going to secure the site, we're going to walk away, and you will be the next one on our list. Was that repudiatory breach? In those circumstances, probably not. As long as there was a clear email chain to say, we can't do the work at the moment, but we will be able to do it when things return to some form of normality. Now, the employer might say, well, I insist that you carry on and do these works now. Well, that's not necessarily a repudiatory breach in those circumstances. Failing to proceed with due diligence, if persisted after reasonable notice, will entitle an owner to terminate for breach of implied fundamental terms. So, if you have been given a notice to say effectively, you as a contractor need to get on with these works, because if you don't complete these works by X date, then that affects the other contracts that we have in place in relation to, say, fit out, etc. Now, if you've been told 2 or 3 times that you really do need to get on with this, and you either ignore them or don't respond and say, well, look, we can't get on with this because, as you know, this is the situation at the present time, then unfortunately that could well lead to a breach of a fundamental term of the contract. Due diligence is to be measured against any agreed or reasonable contract completion dates. Again, going back to when we were all in lockdown, most parties cooperated. And the employer said, yeah, okay, we accept the fact that you've only got half staff at the moment. You can't complete the work. We accept the fact that you can't get the supplies. But the key to all of this is documentation. There needs to be clear email exchanges between the parties which show that they have agreed reasonably to extend time, etc. However, in the absence of express indications such as time of the essence, so you're saying to the contractor, you need to complete these works by time is of the essence wording, completion to time by the contract date, or that date is extended, an extension of time clause will not generally be a repudiatory breach. Equally, when you finish the works, unjustified and continued failure to remedy defective work, which requires removal or repair before further work should reasonably take place, will also be a fundamental breach. So, you're part of a scheme of works whereby your job was to rebuild all the walls on this dilapidated property before the internal works could be carried out. If, when you've completed the remedial work to the walls, there is suddenly cracks appearing, yeah, you've got to be given a reasonable opportunity to repair those cracks. But rightly, the employer might well say to you, unless you do that by X date, then I'm getting somebody else in to do the works. By the way, I am going to charge you X amount of money in respect of their charges. So you need to be proactive. Read the contract in the first place. And if there is a clause in there that says you've only got 4 weeks to repairing defective work, make sure it's done within 4 weeks, unless there is a good and reasonable excuse. Where there is a breach of a term which, while note so by serious, sufficiently serious, may be so protracted or repeated despite protest or notice by the innocent party that it either evinces a subjective intention not to be bound by the contract, as in the case of a deliberate and continual breaches, however minor, or simply an objective involuntary inability to perform the contract properly. So, if you have a series of minor issues, but they keep recurring during the continuancy of the contract, that may well accumulate. A bit like the water on my roof at the moment, and that may well lead to the employer saying, sorry, I've had enough. you didn't do that on that day, you didn't do this on this day, you do that on that day, and you didn't do it, and you didn't do that on that day, and you didn't do that on that day, and you didn't do that on that date, then you're in serious risk of the employer being able to say, sorry, I'm terminating the contract and not paying you. Where a party actually informs the other that he intends not to perform the contract as a whole or any part of it, either presently or in the future, or where he acts in such a way as to render his own future performance impossible. These are normally referred to as anticipatory breaches. So, going back to when we were all in lockdown, a contractor saying to an employer, look, just at the moment, I can't do these works. I haven't got the labor and I haven't got the materials. As soon as things return to some form of normality, I will be able to carry out the works. Then he's saying, look, I don't want to walk away from this contract, but at the moment, because of the circumstances I find myself in, I can't do the work. Now, there's an argument to say that the employer could just terminate and say, well, I've had enough, I'll find somebody else that can. But certainly during parts of last year, that would have been impossible because everybody was in the same position. So what employers were finding was that, okay, it's all right. Yes, an employer might ask around, say, well, can you do it? Can you do it? Can you do it? But the chances are that back then, the answer would have been, well, not really, I can't. But you have to be careful about this. You have to set out your reasons coherently so that if it goes to court, you can say, look, I anticipated that I couldn't do these works. I told the employer. And the employer went, okay, maybe reluctantly, but I did tell him. So again, as has been said by, I think, many of the people that have given talks from, that have given lectures that Julie's hosted, there are communication, record keeping, putting things in writing is the best thing you can do. Burying your head in the sand or not responding to reasonable requests to get the works done on time or bring them back on time is not normally going to work. Where the parties indicate expressly by the contractual language that a single breach of a particular contractual obligation is to have the same consequences as a fundamental breach, entitling the innocent party to terminate the contract, even though it would not otherwise be treated as a fundamental breach, justifying immediate termination. So, going back, you can, in a contract, say any breach of any of the terms of this contract, no matter how minor, will entitle one party, i.e. the innocent party, the person that's done nothing wrong, to end the contract. Now, normally these rights are expressed as basically both ways. So, if an employer were not to have obtained planning permission, etc., then it may be that the contractor can say, well, sorry, I know you're saying it's only going to be 2 or 3 days before we get it through, but I've looked at the contract and in there it says any breach, I can walk away. I'm walking away. Because the contractor may well say, well, he says it's 2 or 3 days. Actually, it might be another 2 months. And I've got other jobs that I need to get on with. So again, going back to my read your policy wording point, it's read your contractual documentation. If you want to have that sort of contract, where even a minor breach amounts to basically termination of the contract, then make sure you're aware of it, because any minor breach of the contract may well be enough to end the contract. There's lots of language that's used in contracts, conditions, conditions precedent, time of the essence, etc. The mere use of these expressions, and particularly the simple word condition, will not of itself be conclusive. The whole contract will be looked at by the court before it makes any decisions. As I said earlier, the court is very reluctant to interfere with parties' contractual rights. The court will assist, and there's a procedure called Part 7 claims, where you can go to the court and say, we don't disagree that we entered into this contract, no problem there. But this clause, the contractor thinks means this. As an employer, I think it means that. Court, what does it mean? Because we can't agree. Now the court will look at that and say, okay, get that. But the court will always look at the whole contract if it is required to give an interpretation as to one clause. It will probably also look at the factual background as to why the parties entered into this contractual arrangement. Now, sometimes the courts are asked to terminate contracts because the contract has been what's called frustrated. Frustration is a very old common law concept where it means that a certain event has happened which renders the whole contract, neither party can do it. So perhaps in my supply contract situation, the supply of materials from one part for the party supplying them has suddenly dried up. I don't know what that could be, might be weather conditions, bad crops, etc. And it may be that the purchaser has said, okay, well, look, I accept that there's nothing you can do about it. I'll need to go somewhere else. The contract in those circumstances becomes frustrated because neither party can really perform under it. But again, the courts are reluctant to find frustration because it ends the contract. There's another concept called force majeure. Some of you, probably certainly on the contractor side, will have seen it mentioned in JCT contracts. Unfortunately, it's not the best way of using force majeure. Force majeure, as you can probably imagine, my French is terrible, is a French term, and it means that something has happened that prevents the parties carrying this out. Force majeure is very clearly defined in shipping contracts. There are a list of examples, especially in shipbuilding contracts, of circumstances where force majeure applies. But in the JCT contracts, force majeure is just chucked in as force majeure. Well, that's fine, but it's got no legal definition here. If you're going to try and rely on a force majeure clause, you need to define what event amounts to force majeure. There's no point in saying subject to force majeure, full stop. Well, yeah, okay, what's that then? In shipbuilding contracts, force majeure is specifically defined, and the courts have no difficulty then in saying whether a force majeure event applies or not. As I said right at the start of this, a condition is different to a warranty. However, just throwing in that this is a condition of the contract, occasionally the courts are asked to decide this important point, whether it's a condition or whether it's a minor term or a warranty. Just putting the word condition in front of everything isn't going to be enough. Conditions are fundamental terms of the contract. So in a supply contract, you haven't supplied the goods and paying for them. But warranting one party that I've always got £10,000 in the bank and then say, and that's a condition of the contract, that's probably not going to be a condition. Where the parties insert express termination provisions for the benefit of the party in certain defined events. Well, yes, you can do that. Such express clauses are, in the absence of express indication to the contrary, additional to and not in substitution for the owner's rights on a common law accepted repudiation. Always assuming that a sufficiently serious breach is present to justify a common law termination as an alternative to the contractual right of termination. Again, we're looking at the seriousness of the breach. As I said earlier, accumulated minor breaches consistent throughout the entire contract may give rise to a termination, but not always. But a serious breach, normally in terms of payment, supply of the goods, carrying out the works, that will always be something the courts will look at. Following a repudiatory breach, the innocent party is entitled to choose whether to treat the contract as continuing or accept the repudiation and treat himself as discharged. If he elects to treat the contract as continuing, he is usually said to have affirmed the contract. So, going back to my example of last year, where you have a contractor who says, look, I can't carry out the works at the moment. My labour force is decimated. I can't get the materials to do the job. I'm really sorry. I hope in 3 months' time, I'll be able to do it. What do you want to do, employer? Employer's got two options. He can say, you know, thanks. I don't think you're trying hard enough. I'll find someone else, but don't worry about it. I'll find someone else. Or he can go, actually, that's fine. I can't find anybody else that can start the works any quicker than you. So yeah, I'm going to stick with you. In which case he affirms the contract. And obviously a party will not be held to have elected to affirm the contract unless, firstly, he has knowledge of the facts that give rise to the breach. Well, last year, I think everyone probably was deemed to have knowledge of the current situation, that everyone was having to work from home, that factories were closed, supply of materials wasn't good, etc. And secondly, and probably most importantly, he had knowledge of his legal right to choose between the alternatives. That's a slightly tricky one because he would have to probably pick the phone up to a lawyer and say, look, what am I going to do here? Hopefully that legal advice would be clear and say, well, you've got two choices. You can either try and find somebody else, or you can just say, okay, I'll wait 3 months. But he has to be aware of those options. It will be implied if, with the knowledge of the breach and of his right to choose, he does some unequivocal act from which it may be inferred that he intends to go on with the contract regardless. So, for example, going back to my previous example, he continues to pay for the contractor for his materials. Or he says to the contractor, that's fine, I will wait 3 months, the new date to start is X. So he needs to do something which the contractor can rely on to say, well, he didn't cancel the contract because he told me, that's fine, I will wait 3 months in an email dated. Or actually, he continued to pay for the materials. Or he continued to pay for the provision of security on the site. In the case of a breach which is persisted in by the other party, the fact that the instant parties continue to press for performance will not normally preclude him at a later stage from treating himself as discharged. Yeah. It sometimes is the case, rarely, but sometimes the case that the employer puts up with continued delays. He may well have moaned to the contractor about these continued delays, but it wouldn't normally stop you as an employer at a later stage from saying, sorry, your performance was woeful. I don't think I owe you any money onto this contract. I'm not discharging myself from it. There will be no successful rescission of the contract, whatever the nature of the extent of the guilty party's breach, unless there has been a clear and unequivocal acceptance of the breach by word or action on the part of the innocent party. Hopefully that's clear now to everyone. There must be clear and unequivocal, and a mere inactivity or acquiescence will generally not be regarded as acceptance for this purpose. So, don't just say anything. Sorry, don't just say nothing. Just go quiet. You've got to do something. Mere delay and acceptance of repudiation will not be a bar. However, the contract must not have been affirmed in any way, or the rights of third parties have been interfered with, or the other parties have altered his position on the basis the contract still subsisted. So you need to be clear, no matter which party it is. In the case of my earlier example of the contractor turning up on day one, the planning permission's not there, he's got the option. He can say, well, hang on a minute. I'm sorry, I've got too much other work on. I am walking away from this. You said we started on this day. You would have all the planning permissions. You haven't. Sorry, that's pretty fundamental. I'm going. Employer has a similar option. Works are due to commence on the site. Contractor turns up 10 days later. You can say, well, sorry, I really am sorry. You didn't let me know why you were going to be late. You didn't tell me you were going to be late. I've now got someone starting tomorrow. I'm walking away from this contract. Where both parties are alleged to have committed a breach of contract, it says that each breach taken independently gives right to terminate further performance of the contract. Regard must be had to the order in which the breach has occurred. Yeah. So both parties are at fault. Let's just say, going back to my earlier example, that no, they haven't got planning permission, but the contractor still turns up 5 days late. Yeah. Now, the courts would look at this and say, well, okay, what was the first repudiatory breach? Probably the lack of obtaining planning permission. No work can start until that planning permission is there. If that was a term of the contract, it wasn't there when the contractor was due to start, the contractor can probably go, sorry, it wouldn't have mattered if I turned up on day one. I couldn't have started work because there was no planning permission. So the fact that I was 5 days late really doesn't matter at all. Now, it could equally be said by the employer, well, yeah, I didn't have the planning permission, but I did then get it 3 days later, and they still turned up 2 days after that. Really? So you have to be careful in those circumstances, but the courts will generally look at which party committed the first fundamental breach. The effects of termination, the primary dual consequence of rescission or termination breach would be first to release the innocent party from all further performance of his obligations, and secondly, to entitle him to full damages, including loss of the contract resulting from the termination. In relation to rights acquired before discharge, although both parties are discharged from further performance of the contract, rights are not divested or discharged which have already been unconditionally acquired. Again, need to look at the wording of the contract. So maybe a deposit's been paid. Provisions such as arbitration and adjudication will be retained in the contract despite termination. Also, increasingly now, mediation. I would say that I'm a qualified mediator, but that's just. So, provisions regarding dispute resolution that were in the contract still subsist even after the contract has been terminated. If termination is under the express terms of the contract may set out the rights of the parties following termination, and it's unlikely that that's going to be different to common law termination. Notice of termination shall not be given unreasonably or vexatiously. This imposes an important limitation upon the power of either party to terminate the contract. What is reasonable or vexatious depends upon the circumstances and may give rise to lengthy investigation and subsequent proceeding. Vexatiously was aid to connote an ulterior motive to oppress, harass, or annoy. There's been a recent case as well on payment notices, which has said that not only does your payment notice need to be accurate, but also you believe it's accurate. Without prejudice to any other rights and remedies, it's clear that this express reservation of any other rights or remedies preserves the normal rights of common law of the party against another. Forfeiture clauses are strictly construed and care must be taken to see that the terms of the contracts are properly complied with. So, in any contract, there will be provisions as to service of notices. So who do you serve a notice on? Where's it got to be served? At which office? Is it the registered office of the company or is it its trading address? There will also be timings in most contracts as to when you've got to serve a notice. So it will say within 7 days of, etc. And there may well be contractual provisions as to what needs to go in the notice. So you need to set out, for example, what the alleged breach is, when it happened, who did it, etc. Wrong interpretation of a contract. Differences of interpretation of parties' obligations under the contract, should they come to a head, will render a party in real peril of a successful adverse termination, should his interpretation prove incorrect, assuming that he has, as a result of acting on that interpretation, prejudiced the further performance of the contract, quite apart from the obvious cases where he may have been led into prematurely rescinding or terminating or abandoning the contract himself. So, going right back to the beginning when I said read your contract, if there are clauses in there that you do not understand, then that's the time to go and get some legal advice. Don't leave it until you've signed the contract and then go, well, I didn't really know what it meant when I signed it. Probably going to be too late. Because if you've interpreted it one way, then I'll say, well, no, that doesn't what it means. It means this. Then that's going to cause you difficulties. Then you have to go to the court, and the court will then make a decision as to who is right or who is wrong. You want to avoid that. What you want to do is make sure that before you sign a contract, you understand what it means, and that the other side is also aware of what it means. If a party refuses to perform a contract giving a wrong or inadequate reason or no reason at all, he may yet justify his refusal if there were at the time facts which would have provided a good reason, even if he did not know them at the time of his refusal. So, give a good reason why you can't perform the contract. There is some case law, and I have to say only some, that says, well, you know, I didn't quite know about that at the time, but I thought it might happen. That may be good enough, but I would suggest you're on sticky ground. To conclude then, in the same way as I say about reading policy wordings in insurance contracts, because that's your contract with your insurer, you need to read your contract carefully. The courts are reluctant to interfere parties' contracts because they assume, rightly, that you've both entered into this, you knew what you were doing. It's not up to us as a court to say, oh, you shouldn't have done it. Courts will never say that. The best they'll ever do is assist in interpretation of the contract. They will assist in enforcement of the contract. They may look at circumstances in which frustration or force majeure applies, but they are very unlikely to say ever, well, you shouldn't really have done that. That's not their job. They assume that you read your contract, you knew what you were signing, excuse me, and therefore you're bound by its terms, absence of pressure at the start to sign a contract, which rarely is found, or some other intervening unforeseen action has taken place which renders the contract null. So there we go. Thank you very much indeed, everyone. Thank you very much indeed for attending. I do hope the rain wasn't too hard and everyone heard me. And there we go. And oh, look, hello, Julie, you're back. See, I got policy wording in. I told you I would. I always get policy wording in, even in talks which have got nothing whatsoever to do with insurance.
It's like a form of construction bingo with you, John. It really is. Thank you
so much
for that. As always, if you've got any questions, now is the time to ask, or alternatively, as we previously mentioned, if you'd like to email John directly, it is jon.sharp@fletcherday.co.uk. We are back again tomorrow evening with Mohammed Haq, who's going to be talking to us about innovation in construction contracts. If you haven't booked for that, but you would like to log in, please drop me an email, seminars@fletcherday.co.uk, and I will get you the login details. Otherwise, have a good evening, everyone. Thank you to Jon for his time this evening, and thank you to you all for attending, and we hope to see you online again very soon. So good night, everyone. Thank you, Jon.
Thank you, everyone. Thank you, Julie, as always. Take care.
Take care. Bye-bye.
Bye-bye.